All right, let's try this again. Sorry, we've been having some technical issues today, but thank you for joining us again for our weekly Ask an Attorney Anything. This week, I'm not really going to be focusing as much on the law. Going to be a little bit more about conversations, especially surrounding estate planning and how those can be really difficult for some families and how to best approach those. So, again, hi, my name is Heather Ward. I'm our estate planning associate attorney at the Legacy Legal team. This is pretty much all that I do for us. And I see a lot of people come in for consultations that their child has said, okay, we really need to get this done. When I see the other end of the spectrum where it's somebody's very sick and needs something to be done right now. And no matter when you have the conversation, sometimes it can be hard because people don't want to think of this. They don't want to think about dying. They don't want to think about if they're going to have anything left. They don't, some people are okay thinking about like their legacy that they're going to leave. It's a hard fact for a lot of people to say, okay, if I died tomorrow, what do I want to happen? Or even down the line, it's not something you really want to think about. I'm going to talk from both sides, whether it's you having the discussion with your own family about your own plan versus, for example, speaking with your parents or your grandparents or brother or sister about the need for estate planning, when to have that conversation, all of those good things. Um, Having these discussions are really important because it's going to make sure that person's wishes are honored and it's going to minimize conflicts. You always run the risk of, if there's not something in place or we waited until the last minute to have the discussion, that somebody's going to have an issue with what was said or what was done, because there are some bad people out there to where they take advantage of the situation, even though that's not always the case. The first thing to really think about is starting that conversation early. Like I said, I have a lot of people that come in at the very last minute and they're like, I just got an awful diagnosis. I'm in the hospital about to get discharged to rehab, all of those types of situations. It's not the best time to make really important decisions when you're under that kind of stress. Of course, we're happy to help you in that situation because that is really a time when you need to have things in place. But it's a lot easier and less stressful, obviously, to have this discussion before that time comes, because then you and your family feel comfortable knowing that there's a plan in place if you pass, and there's a plan in place if you become incapacitated or need assistance, especially if you're in a rehab facility and you can't go anywhere. Like, you need somebody that can do things on your behalf. So, number one pointer that I can give is start that conversation early. If you are approaching your family members about the need to get it done for them, make sure that it's in more of a relaxed situation. It's not you're coming at them, bossing them around, telling them what to do. Because, if you're going to your parents trying to tell them you need to get this done, it might come across the wrong way that you're concerned for the wrong reasons about why you want to get this plan in place. We always recommend like just having a really private moment, whether that's just you with your parents or your children, whether it's people that are going to be involved, whether or not that's somebody that's going to get any sort of inheritance from you. Start early and do it in an appropriate setting. Obviously, the way that you talk about these things is really important. If it's you're setting up your own plan, it's really helpful to be, upfront about what your intentions are and your reasons behind it. This, of course, all hinges on how much you want your family members to know. Not everybody does an estate plan and wants their family to know what it says. They may want to know, hey, if something happens to me, I have something in place. You're the person that's going to be handling things, but not necessarily know the details of it. There are also families that want the family members to know the details of it because there's reasoning behind it. For example, some families, they have one child that needs a little bit more help than the others because they've already got an established career and family and all of the things. And so they may want to help out the younger sibling or whatever it is. Sometimes people want them to know that there is a difference and what that reasoning was, because it makes that hit a little bit less of an issue than being completely shocked and saying, okay, hold on, why did mom or dad do it this way? And again, that's all entirely up to you. You do not have to tell anybody anything. It's not ever really anybody's business unless you want it to be. As far as the decisions, it's really important that you talk to your attorney to explain why you want things done a certain way, because we're really there to help you do the plan in a way that makes sense, but also be able to give you some direction if you're stuck. Okay. I have two daughters that are a year apart, and one lives here, one lives out of state, but one's way better with money and one would be better to make healthcare decisions. That is all discussions that you can have with your attorney to really decide what is going to be the best plan for you. If you're wanting to have this discussion with somebody for their own estate plan, it's not you're talking to your parents again, for example, make sure you really approach that discussion with empathy and make it clear that we're here to do this for you. We're here to do this to make sure you are taken care of in the way that you want to be taken care of. We don't care about getting anything when you pass, but we want to make sure that you're taken care of the way you want to be and that your legacy is continued when you're gone, if there's anything left. How you frame these discussions is really important from both sides, whether it's for your own plan or for a loved one. Another really important step that I think a lot of people skip before they come to see me is at least educating themselves a little bit before coming and talk to the attorney. Of course, Google is one of those things where it's great when it works properly and when you find good sources. Not always the case. There's a lot of misinformation out there, especially because the law does differ from state to state. So if you're not looking at a Florida specific website, it may not be true under Florida law. So one thing that can be really helpful, either before coming to see the attorney or even before having the discussion with family members, if you're wanting to approach this topic beforehand, is having a general knowledge of basic estate planning terms. What is a will? What is a trust? What is probate? Who works under a power of attorney? It's very helpful to have at least the basic understanding, because if you're having a discussion with somebody about who's going to best serve in those positions, you need to know what they do. Of course, this is what an attorney is for. They're going to educate you. They're going to tell you what the different documents do and who is a good fit for those positions and how to accomplish your goals. But that's one reason why, whenever you schedule a consult with us, we send you a little bit of information ahead of time that kind of explains what all of these documents are so you can be thinking about it. Because it's really hard to go straight into a meeting and have absolutely no idea what's happening. And then you're like, I don't know when the attorney asks you questions. I don't know how I want things to be split up. I don't know what documents I think I need. I don't even know what assets I have. That's always a fun one to talk through when people are like, I don't really know what I have. But it really can help to have that context, especially when you're dealing with people that are elderly or very young. If you have a 20-year-old child, they're going to know what any of this stuff is. You tell them they got a trust and they think it's because you're trying to keep them from getting their money until they're 50. If not what a trust is for, can do that, but that's not necessarily what you got it for. So if you're having that open discussion with your loved ones, it's really helpful to have those basic terms to be able to talk through things with them. Another really helpful thing when you're going into that discussion with friends or family is to have a personal situation that you can talk about. If you had a friend whose husband died and had an awful experience in probate because things weren't handled properly, like that kind of gives some context and it shows what could happen if nothing's done. Again, I don't want you to come from a point of being scared, but it puts things in perspective. Like I said, it's really your preference of whether you want to involve friends or family in the discussion ahead of time before you go and see an attorney. You may choose to have a family meeting beforehand. You may choose to bring some people with you to the meeting with the attorney. But the benefit of having people involved in at least the initial discussion, even if it's before going to meet with the attorney, is again, you're providing some context, you're being transparent. It's not going to be a surprise to anybody that you went and got estate planning done and the reasoning for it. It's also helpful to have the people that you have in mind for like your personal representative or your executor, it's called in some states, your trustee, your power of attorney, those people that you're thinking about putting in those positions. Sometimes nice to give them the heads up and have the discussion with them ahead of time. Hey, what would you be comfortable with? If I put something in place, would you be comfortable making that really hard decision to pull the plug if I need you to? Um, the last thing you want is you think that you've named somebody in this position who's just absolutely going to break down when they have to make a really hard decision, because that kind of goes against what you wanted to do. Really, it makes clear what everybody's responsibilities are going to be. Again, you don't have to do this. At our firm, we do offer the ability to send letters to the people that you've named in positions once you've signed the documents. And we simply say, hey, you were named in this position, whether it's first in line or later in line. Um, if something happens, call us. That way they at least have it on their radar that if something happens to you, that they have an attorney they can call and talk through and make sure that you're doing what they want to. I have other families that are saying, let's have a sit down and have a family meeting right now as soon as we sign these documents so that everybody knows exactly what needs to happen and when if something happens to me. But no matter what, if you know you're involving people in this meeting ahead of time or even with your attorney, it's really important to make sure that the person who's signing those documents remains the main focus of that discussion. You don't want it to turn into, but if my daughter inherits, I want to make sure that she doesn't get her money until 25. Not your decision, it's your parents' decision or whoever's signing the documents. Keep the focus on them, what they want, and really keep that focus on we're not even worried about what's going to come when you die. We want to make sure that you're taken care of while you're here. We want to make sure that you have somebody that you trust making decisions for you. Like I started out by saying, this is a really emotional topic. I have family members who I can talk through this with, and they don't care because they know it's a fact of life and they need to get this stuff done. I also have a lot of family members where if I sat down and started talking to them about death, they would immediately shut down and not want to talk about it. So you have to know who your audience is when you're having this discussion, even if it's not the person that is going to be doing the documents. If my mom sat me down and said, hey, I'm thinking about getting estate planning done. First of all, my first thought if I wasn't an attorney was like, oh my God, are you sick? Also, it's really one of those things where you want to think through how you're going to address it to make sure you're getting your point across, you're wanting to leave your legacy, you're wanting to make sure you're taken care of, but addressing the emotion, but not really focusing on the emotion. And that's really what can sometimes be helpful to just start that conversation with your attorney. Like I said, get some background information, talk through a little bit of things ahead of time. But your attorney can really be somebody that facilitates the discussion for you, which is why it's really important to work with somebody that you feel like you can have a little bit more of a personal relationship with, where you feel comfortable talking about the intricacies of your family dynamics, where you feel comfortable telling them about your concerns, where you feel comfortable saying, I don't want to die and I don't really want to think about this, but I need your help because I know it's important. And then your attorney can take that over. One thing to note, if you are taking family members to your meetings with you, you will likely still have to meet with the attorney. No, you will have to meet with the attorney by yourself. We always ask family members to step out of the room just so that we can make sure that there's no influence, that daughter didn't bring mom when none of the other siblings know about it, like those kinds of things. I do have some clients or potential clients that are a little thrown off by that because they're like, oh, why do I need to step out? And it's not because they're distrustful. They just were never warned that we would have to talk to whoever by themselves. And we bring them right back in once we get the okay. Just a thing to note also, if you are bringing people to a consultation with an attorney, really think that through because if you get too many people in a room with too many opinions, you're not really going to get anywhere. And it gets to a point where you feel overwhelmed. So if you think that there's going to be too many people that want to be involved, then come by yourself and you can have the discussion after meeting with the attorney because the way that those consults work is we go through your paperwork, what you submitted ahead of time so we can have an idea of what plan is going to be best for you. Then from there, you can go home and make a decision. No decision has to be made that day. So if you want to go home and talk to your loved ones about it, that's what we encourage. We want you to go home, think it through, feel comfortable before you decide what route is going to be best for you. It's really important when you're having these discussions, especially if you're from a less agreeable family, I guess is a nice way to put it. If you think that there's going to be concerns about somebody saying that you influenced mom or dad to do something, when you're having these discussions, make sure you're writing things down. Mom said this about this, and this is why. Obviously, as an attorney, I do all of that when we have the initial discussions. But if you're having multiple discussions before or after the consultation, sometimes it's helpful to write those things down. And it also helps refresh memory when you go to talk to the attorney later and say, oh, didn't we talk about this? And then the attorney can take what you've talked about and put it into legal words and tell you the best way to accomplish that. Also very important to do that even once the estate plan is in place. Uh, one of the documents that we do for just about everybody is a designation of healthcare surrogate, which is these are my medical wishes. This is the person who enforces them. We give you a little checklist of healthcare things to talk about. You are going to sit there and talk about whether you want your leg amputated. You're going to talk about whether you want life support. You're going to have these hard discussions with the person that's going to be your surrogate. Super important for the surrogate to sit there and write it down, or at least remember that they're talking about it, because that is something you're going to need to remember if you are the person that needs to make that decision for them. That's just one example. Also helpful to have a discussion about if something happens to me, I want to continue to make these gifts to family members. I want this to happen to my house. I want these things to happen, because while we do most of the planning now, it's important to know whether you prefer to spend all of your money and have a real good assisted living facility, or if you'd rather do everything you can to save money and you'd rather go to your kids than to a facility. Obviously, most people prefer that first option, and most kids prefer that first option for their parents as well. But it just goes to show how important it is to have these discussions before, during, and after working with an attorney. And obviously, things change. Your beliefs might change. Your wishes might change because you had a new grandchild or one of your children passed or whatever the reasoning might be. That's why we find it really important to have continuing relationships with our clients. We want you to come back and see us often so that we can make sure you're doing well, to make sure there aren't updates that we need to prepare for. And again, that's something that can involve family members if you want to. It might be your kids have gotten older and now you want them to know what the estate plan says. We really are big at our office with you feeling like you have an attorney and somebody that you can go to if something's going on in your life. I know Meredith and I both really strive for that. I know the other attorneys that work in other areas, they feel the same way. But really, what it comes down to is starting this process early. Nobody wants to do it, but do it, because honestly, once it's done, you don't really have to address it again. You don't have to think about it again unless there's changes. So get it done early while you are in a good mindset to deal with it. And then once it's done, unless something crazy happens, it's really important. I was preparing for this and I had seen another attorney call estate planning an act of love and responsibility. And honestly, I couldn't agree with that more, because whether it's you helping family members set up their own estate plan or whether you're doing your own estate plan, you are doing a huge benefit for the people that are going to come after you. You're going to make things a lot easier. You are likely going to make things cheaper. And for most of my clients, those are their two biggest goals when they come in to do estate planning. I want to make this easy for the people that come behind me. I don't want them to have to deal with court. I don't want them to have to spend all this money in probate to get the normal thing to happen. So it really is an act of love and responsibility. It's going to make sure that your wishes are honored, that your assets are protected in the way that you want them to be, and really make things easier on your family when it's already a difficult situation, whether you're sick, whether you've passed. Getting all of this done ahead of time really makes things easier on your loved ones. So again, didn't really talk about the law a whole lot today, but I've just really seen with a lot of my clients lately that a lot of them have been putting it off until the difficult time. They're putting it off because they don't want to think about it. And so I wanted to just come on here and talk to you person to person, not even lawyer to person, and just talk about, I recognize it's a hard discussion to have. I do this for a living and it's still a difficult conversation for me to have with my family. So get started early, find a lawyer you trust that will help walk you through the process and make it as easy as possible, and involve as much or as little as your family as you want to in that discussion, because it's really up to you and what you guys want to do for that. I'll stay on for a few more minutes if y'all have any questions about how to approach these topics, estate planning in general, anything like that. I'm happy to answer them. Like I said, I'll just stay on for a few more minutes. In the meantime, if you do decide that you want to get some estate planning done, feel free to give us a call. We do a lot of different things at the firm. But like I said, my focus is really on estate planning and a little bit of business stuff, which has a lot of overlap. Okay, so I do have a question. What documentation, if any, is required to create a trust? And will I need to bring this to the initial consult? In order to create a trust, you have to create what's called a trust agreement, which is basically the set of instructions for a trust that the trustee follows. There's a lot that goes into customizing a trust for you. And so usually when we are meeting with a potential new client, we send over some documentation to them, again, educate yourself a little bit before we send over some pamphlets and stuff like that for you to review. And then we have a pretty hefty questionnaire that we do send over so that I can get a feel for you, for your family, for your assets. And then that gives me some direction of whether I should talk to you about trusts, whether I think a trust is a good option for you, or whether we can actually go what I call the cheaper, easier route, which works great for a lot of people. But there are some people where it just makes way more sense for them to have a trust depending on what they want. But that is really the importance of filling out the paperwork that we submit to you. A lot of people feel uncomfortable filling it out completely because they're like, I haven't even hired you. Why do you need to know all of this? Just generalize things so that we can, if you have a house, I'm going to be talking to you differently than if you don't own a house. And it's simply because that's another asset I need to talk to you about. So just make sure with whatever attorney you at least give them enough information to go off of. And along with that, you have to be honest with your attorney. I have had people in the past that kind of want to be secretive with me. And I understand that to an extent because you haven't hired me yet, but I also can't advise you properly if I don't know all of the facts. So again, if you don't feel comfortable with that attorney for whatever reason, find one that you are. But make sure that you at least give them enough information to go off of. And then, of course, you can talk details once you're retained. And a trust isn't for everybody. It's really great for some people. For some people, it doesn't make sense. We really pride ourselves on not selling you something that you don't need. I always tell clients, I'm going to talk to you like you're my family. I'm not going to sell you something that I don't think you need. All right, just down for a couple more minutes for any questions, but thank you for joining me in the middle of your Thursday. I cannot believe it's almost September, which is crazy. But if anybody has any other questions, feel free to leave a comment and we will get back to you or give us a call at the office and we'll get you scheduled to meet with me for a consultation. And then I got one more question that I'll take before I get off. Who would be the best person to select as my executor for my will? And that can be really hard to decide for a lot of families. Usually, when you pick somebody to be in charge of things, you choose the same person across the board, but it doesn't always need to be that way. For your personal representative or executor and your trustee, those are all interchangeable. Trustee is in charge of the trust, personal representative is in charge of the probate estate. To recommend that you look for somebody that's a little bit more, I don't want to say business savvy because they don't really need to be business savvy, but they need to be organized. They need to be able to look through what you have and say, okay, this is the assets. This is what their will or their trust says that I need to do. I know where their attorney is. They need to be organized enough to be able to locate all of those things and deal with it. They also need to be somebody that can maybe have a harder conversation with other family members that may have thought they were getting something and didn't. It really is going to depend on your family dynamics. Sometimes it's just people pick the oldest child because they're the most responsible and that's the easy decision. Some people also prefer to choose the child that's more local. In Florida, a personal representative does have to either be related or a Florida resident. So if they're related to you, they do not have to live in Florida. But if you're just choosing your friend or something, they do have to be a Florida resident. But other than that, there's really no requirements of who can serve in those positions. And again, that's a discussion that we'll have with you because sometimes it may not be the same person across the board. You may choose that you want a personal representative to handle a very small amount of your probate estate. And then you have somebody else handle your trust. It all just depends on the specific mix for you. Another question I will answer because this is a really good question is, can children be listed as power of attorney? Anybody over the age of 18 can be named as your agent under power of attorney. It's not always the best option to just name your kids just because you're kids, especially if they're younger. I can tell you at 25, I should not have been serving as a power of attorney, and I was in law school at that time. You really want to have somebody that you trust with your life. A power of attorney is a really powerful document, especially in Florida, because it's valid as soon as it's signed. There's some things that go into that we'd talk through with you, but you really want to choose somebody for your power of attorney that you trust with your life. They can sell your house. They can call the IRS and get your tax return. They can wipe out your bank. They can do anything you'd be able to do yourself. Generally, that's the way that a power of attorney is drafted, and there's a reason for that. But you may not want to just automatically choose your child as your power of attorney. Or again, that's a discussion that we have with you to make sure that you have people in the positions that you want them in and that you trust them in. So again, thank you guys so much for joining me. Hopefully today was a nice break from hearing about all the legal stuff and give you a little bit of direction on how to have these hard conversations with your family and loved ones. Again, give us a call, send us an email, do whatever. We're happy to help, and we do free estate planning consultations. So even if you do just want to get some context and talk through things, I'm happy to meet with you and do that. And then I hope to get to meet with y'all very soon. Have a good rest of your Thursday, and we'll see you soon.